Welcome to this edition of Real World Employment Law, where we discuss real-world issues impacting businesses and executives. I'm Declan Leonard. I'm managing partner here at Berenzweig Leonard, and I also head up our firm's employment law practice.
And I'm Samy Abdallah. I'm an associate here at the firm, and I work a lot with Declan and the team in the employment law cases that we handle.
And Samy, it's great having you here. Your first time on camera in this BLC Digital Strategies studio here in our offices here in Tyson's. We got Todd Castleberry out there manning the board and producing us here today. Your first time on camera here, but not your first time on camera. Spent, if anyone out there recognizes this face, Samy was the law clerk for the judge who handled the Johnny Depp Amber Heard case, and so every day on court TV. Yeah. I mean, did you actually have to take a shower in the morning on the way in, or?
I kept by my my normal morning routine, but it was a bit odd having that realization every day of I'm just going to be on camera for the next 6 weeks of my life.
What an experience! We won't get into that today. Maybe that'll be another podcast. But what an experience for the first year of your legal career to kind of sit through and see that unfold before you.
Mm-hmm. No, it was a great time, and it was a fantastic experience.
Yeah, I'm not sure how to segue from Johnny Depp, Amber Heard, and some of that testimony that we heard to what we're going to be talking about today, which is, maybe a little drier, but a very important topic. Mm-hmm. So we're talking today, the topic of this is kind of understanding the intersection between the FMLA, which is the Family Medical Leave Act, and the Americans with Disabilities Act, the ADA. Mm-hmm. Sam, let's start off. Why is this important? Why do our clients care about this? Why has this been an issue that our clients have asked us about?
I mean, I think a lot of people try to view the FMLA and the ADA as two separate bodies of law that don't really overlap all too often. But in reality, people's medical emergencies and people's medical and employees' medical issues can create overlap between these two bodies of law, and we always need to be thinking of them at the same time to a degree.
Yeah, so I think that the dilemma is this. You can't predict the time limit or the time that a medical condition is going to persist for an employee. So, let's talk about these. Let's talk about why there is this tension. So the Family and Medical Leave Act. Today we're going to be talking about medical conditions that impact just the employee. Mm-hmm. And am I right that the Family Medical Leave Act goes beyond that? We cover some other things.
It does. It covers pregnancies. It covers medical emergencies of those in your immediate family. It's not just a body of law that covers an employee's own medical emergency, but I think that's just all we're going to be talking about today.
Yes. So today, because that's when the ADA intersects with it. I mean, the ADA is not going to necessarily come into play when it's an immediate family member that you're taking leave for. The ADA really has to pertain to the employee itself. So let's talk about that. So the Family Medical Leave Act. First off, for companies out there, for executives out there that are looking at this and saying, how does this apply to me? What companies does the Family and Medical Leave Act apply to?
Yep. So the Family Medical Leave Act, it applies to employers that have 50 or more employees that all work within a 75-mile radius of an office that is run by the employer. So this isn't an or situation. You actually do need both to be covered by the FMLA.
50 or more employees. So that's your first inquiry. And then if you've got more than 50 employees, then you go kind of the second one and say, okay, but are those 50 all located within 75 miles of, let's say, one of our offices?
Yep.
Sounds like an easy analysis on the 75-mile radius. What do we see in practice?
In practice, it actually becomes really difficult, especially now, in the post-COVID world where you have a lot of employees who report to work virtually and have maybe never even set foot in one of their company offices. The 75-mile radius analysis can get a bit tricky, and it actually remains an unanswered question from the U.S. Supreme Court as to how remote employees actually factor into this analysis.
It's very fact intensive. If you've got a company that's based here in the DMV, let's say it's in Virginia here, but you've got, and you've got 50 or more employees in this jurisdiction. So you cover that first aspect or that first prong of the FMLA. But then you've got an employee who needs leave under the Family Medical Leave Act, but is working remotely. a casualty of COVID in terms of moving out of state and is in Texas, then it becomes a very fact-intensive inquiry as to whether or not that employee can sort of piggyback on the Virginia headquarters to qualify.
Yep. And it's I think this is something that's going to create a lot of headaches and a lot of problems and a lot of different outcomes across the country.
Okay, so let's just assume you and I'm going to point one other thing out. That's the Federal Family and Medical Leave Act. There are also a lot of states, and in this case, districts like the District of Columbia, who have passed their own family and medical leave laws, and they have different thresholds. So for DC, it's 20 or more employees. It's actually done over a 24-month basis. So we're not here to give a tutorial state by state, but just be mindful that when your employee asks for family and medical leave, don't just stop at the federal level. You might very well be subject to a state, or in this case, the Washington, D.C.'s law, because it's only 20 or more employees located in D.C. Okay. An important part of the FMLA, is it paid or unpaid?
It's unpaid, so employers don't need to worry about, continually cutting checks to their employees while they're out on leave, but the employee is still going to be able to avail themselves of, the benefits that they get through their employer, such as health insurance and other benefits.
Got it. Okay. And so tell me, what if an employee, kind of needs to still have income during this period of time? How can they substitute in some paid leave? What are some avenues in which employees can still, while they're on FMLA leave, concurrently also get some pay in the door?
So one option is to, employers through their company handbooks, employee handbooks, they could substitute in sick leave during this time. I know employees a lot of the times, going 12 weeks without pay can be an issue.
Huge hardship.
So substituting in some paid leave during this time can really alleviate some of that financial burden that comes with taking 12 weeks of FMLA leave.
A lot of companies also have short-term disability insurance, and I see this causing a lot of confusion. That's an insurance policy that companies purchase, but you can go on short-term disability. An employee can go on short-term disability. But the important thing is companies still should record that same time frame as qualifying as part of the FMLA leave allotment for that employee. They kind of run concurrently.
Yep, exactly. You don't want to separate these things out just because of their different names.
Some states have also come into play and sort of supplemented pay.
So yes, you have Colorado and California, for example. You'll have some supplemented pay during your leave during this either federal or state equivalent level of family medical leave.
Yeah, closer to home, D.C. did it. Massachusetts has done it. And basically what they've done is they've set up like a system, their own little system that companies pay into, employees pay into, where if somebody needs to take leave, they can then, kind of take advantage of that. It's usually not going to be 100%, and it's usually of a limited duration. The other thing is you talked about whether they could take sick leave, and that's correct. Talk about some of the difficulties that come into play with these companies that have instituted unlimited paid time off, and whether or not how that works with FMLA leave.
Yeah, so an issue that arises with this unlimited paid time off or even a flexible paid time off policy is that it becomes an undue burden on an employer to allow someone to take, up to 12 weeks of leave with even though you may have an unlimited PTO plan. And this may be alleviated in a company handbook or employee handbook by saying that this PTO, even though it is unlimited, is something to be used for leave that is not related to being sick.
Yeah, that unlimited word, I think we generally try to advise our clients to come up with an alternative, whether that's FTO, flexible time off, things like that. Unlimited really is not meant to be unlimited. I mean, because then you could theoretically just, take the full 12 weeks as paid leave under an unlimited PTO policy. I don't think that's the intent of it. I think unlimited is really more designed to be flexible and not, so rigid that you're looking at your pay stub saying, how much leave do I have? Can I go away for a 3-day weekend? It's supposed to be a little bit more flexible on that. Okay, so we talked about who qualifies for family and medical leave. We talked about how under the federal system, it's 12 weeks, okay? And then let's say an employee gets to the end of the 12 weeks and they still have recuperation time. They still need maybe another surgery or something like that. That's when this intersection with the ADA comes into play, correct?
Yep, that is exactly when the intersection comes in. Just because when someone is coming to the end of their FMLA leave, and may need maybe an extra month, an extra week, an extra 2 months, you shouldn't just deny their request for additional leave at the end of FMLA. You should really start considering what obligations you may have under the Americans with Disabilities Act, the ADA.
Yeah, and so these two laws, I mean, at first you think they're so different. One of them provides leave and presupposes that you're not going to be working, the family medical leave. I mean, that means you're staying home. That applies to 50 or more employees. Then you've got the Americans with Disabilities Act, which is the exact opposite in many ways, because it says I can actually perform my job. I just need an accommodation. I need a reasonable accommodation. And it actually applies to a smaller number of smaller employers, 15 or more under the federal system.
Yep. And so under the ADA, a lot of people don't realize, but a lot of courts have held, and I think it is reasonable to say that leave can be an accommodation. An accommodation doesn't necessarily have to be something like a standing desk or additional break time. Leave is an accommodation, and it can be an accommodation in many instances. It's not going to be an accommodation in every single instance, but it is something that is an accommodation in a way.
And we've seen companies where, not our clients, but we've seen companies in other cases where they institute policies where they basically said, look, at the end of your family and medical leave, 12 weeks, if you can't come back, you're out of luck. You no longer have a job. Mm-hmm. And how have the courts responded to that?
So courts are very wary and really don't like those policies that are written that say at the end of your 12 weeks, it doesn't matter what status you are, you have to return to work. That creates a lot of liabilities, that creates a lot of issues, and this almost one size fits all method or approach is really inadvisable because it can lead to liability under the ADA.
Yeah, we saw a case. A trucking company in Colorado basically had that policy, and they put it in writing too. So it wasn't even an unspoken policy. They put it in writing. They got hit with a lawsuit basically saying this is a violation of the ADA. You're not doing this on a case-by-case basis. You're doing this just full-blown. If you can't make it back, we're not even going to consider any leave beyond 12 weeks. They got hit with almost a $5 million judgment. So this is a pretty potent process. So what is the analysis that companies should do? Let's just say an employee comes to you. They've taken their full FMLA leave, and then they come to you and they say, I need a little bit more time. What should employers do? Like, what's kind of the process?
So the ADA requires something that is called the interactive process. You should engage with your employee who's requesting this additional leave, but there are a lot of considerations you should be considering when this additional leave request is made, such as how long is that leave going to be? What position does this employee currently have? Is their continued absence or leave going to create an undue burden or hardship on the company? And to what extent can you expect that the employee will indeed recover if that additional leave is provided as an accommodation under the ADA?
You used a great phrase, interactive process. I know the ADA is so keen on that. And so, if the employee comes to the employer and says, hey, I need more time, if the company's knee-jerk reaction, even if they don't have the written policy that got this one company nailed for $5 million, if the company's knee-jerk reaction is, we really don't do that here, or we've never done that for anybody here, so there's no precedent for that. That's not gonna satisfy this interactive process and doing it on a case-by-case basis, is it?
Nope, it's not. You really have to analyze and assess what request the employee is making, see if it's going to work. A defense such as we've never done this before is really just not going to fly in a court. Courts really want you to have when the courts say they want you to have this interactive process, when the ADA requires this interactive process, they really want you to really honestly just have a frank discussion with the employee and see if it will actually work with your business model.
Yeah, and it also focuses heavily on what is the role of the employee at the company. I mean, if the role of the employee at the company is like, they are the ones that are managing the source code for a very important, let's say technological platform at the company, you can't just bring in, a temp worker, or you can't just like reallocate some of those duties. So those are the things that the company really has to look at and make a good faith. They can't just say, "Oh, we can't keep your job open." Just kind of knee jerk. We can't keep your job open. You got to be able to explain why. If you can't explain it to the employee, you ain't going to be able to explain it to a judge down the road.
Yep, exactly. But on the other hand, there are certain employees, like you said, that do need to report to work regularly, and courts have agreed that for certain positions, regular attendance is a requirement of is a bona fide requirement of a position. And like you said, with the employee who is handling source code, doctors or nurses, I'm not going to sit here and say in every single instance, but in most instances, regular attendance for those types of positions is going to be a requirement that will be difficult to accommodate.
I think that's correct. And then so you sit down, you do the interactive process, you kind of talk back and forth, you talk internally with management and say, can we do this? And then what kind of documentation should the company be asking for as they're evaluating this?
Employers should regularly ask the employees to provide some sort of medical certification or documentation from a medical provider. You should never put yourself in a position as an employer as acting as a doctor.
That's always a mistake, yeah.
And assessing from your own point of view whether or not an employee is going to, the ailment an employee is suffering from will only require a week of absence. Yeah. That's something that medical certification and medical professionals should be left to do. We don't want to have employers be put in the position where even an employee without medical certification is saying, I can be back in a week. Well, what happens if that week elapses and the employee needs more time? You don't want to get into a rolling situation where
two more weeks or two more, the employee has an incentive to kind of, I wouldn't say sugarcoat it, but maybe minimize the time frame, because the less they're asking for at the front end, the bigger the chances that the company is going to agree to it. And you're right. You don't want a situation where it's like, I should be good in 2 weeks. Don't take the employee's word for it. Just say, okay, fine. Just have your doctor tell me when your return to work is in writing. There's forms that just put this on there. So that's definitely one. So you definitely don't want to take there. What if the employee and the doctor, what if the doctor comes back and says, at this point, it's hard to ascertain. It's almost like indefinite. What do you think a company should do in that instance?
I think at that point, if an employee's physician or doctor is saying, we don't know how long the leave is going to be. It's indefinite in a way. The EEOC and courts have regularly held and said that indefinite leave is not a reasonable accommodation.
Yeah, it gives the company no guidance. I mean, companies are planning and they don't know, am I bringing somebody in to substitute for this person for 1 month, 2 months, 3 months? So I think you're right, and I think there's a middle ground that companies often don't take advantage that I think could really strengthen their case if they ever got sued under this, which is to basically say, listen, sounds like for these indefinite situations, sounds like you've got a tough medical situation. We obviously extend our sympathies. I hope you can understand that we can't keep the job open, but what we will do is this: why don't you, when you do get written medical clearance from your doctor, why don't you reapply for the job? I mean, we're not going to foreclose you from doing that. I think that would go a long way, but I think companies sometimes forget to do that.
I agree. I think it would mitigate a lot of risk under the ADA to just allow an employee when they are medically certified to return to work, to reapply for that position when it's available. You know, you never want to fully close the door on an employee who is, one, having a medical situation that may require indefinite leave, or two, is trying to engage in the interactive process, but just doesn't have enough information to really say when they can return to work.
So we know kind of on the back end, indefinite leave, that is almost the closest thing we'll get to a bright line test where you can kind of deny that and not run afoul of the ADA. How about on the other end? Have you, are you seeing anywhere where there's a bright line rule that 1 week, 1 month, 2 months, 3 months is going to be okay and deemed to be a reasonable accommodation under the ADA?
So from what we've seen, courts have said that a month is a reasonable accommodation.
Still case by case, but a month they can stomach a little bit, yeah.
Mm-hmm. And that, intermittent leave is something that is also available.
And explain what you mean by intermittent leave.
Intermittent leave is leave where an employee will work for let's say a couple of months and take 2 weeks of leave, come back to work, do another couple weeks of leave, and then it can get reassessed every now and again through certifications through the medical professional
Got it.
Employee.
So the thought behind that is it's not an undue hardship because you're getting not fully that employee's work, but you're getting a lot of that employee's work. Mm-hmm. They're in there, they're showing up, they're not showing up full time, but it starts to take away some of the sting from their absence if they're able to do that a little bit more. Mm-hmm. And then in terms of even with companies not faced with this issue currently, they should be aware of it. But what, if anything, should they be kind of looking at internally at their own documents to make sure that they're, that they've got their ducks in a row if this turns into an issue?
So I think, you always want to make sure that your employee handbooks are up to date with the current requirements under the ADA and the FMLA. You want to also make sure that not just that they're up to date, but that these policies are being adequately communicated to your employees. You don't want to get into a position where an employee is just completely unaware of the company's policies on paid time off for sick leave or FMLA leave or ADA leave. Additionally, employers should really make sure that the process to request this type of leave or to request accommodations is streamlined and either goes directly to HR or in some instances, maybe in smaller companies, goes directly to the employee's direct manager.
Great practical advice. Samy, I cannot guarantee that this podcast is going to get the same ratings as your other time on TV with the Johnny Depp trial, but I think it's very helpful. I think the material that we covered today is very, very practical for companies. These are issues that we didn't just pull out of thin air. Mm-hmm. These are issues that we advise our clients on all the time, and so that's what we try to pick when we do these real-world employment law podcasts. Thank you so much for joining us.
Thank you. I appreciate it being here.